Hey everybody, we are back in the shanty. It's a warm, rainy evening here in the shanty. We had some thunderstorms today. I was on the road, and I'm going to be on the road again tomorrow, which is interesting. 2 weeks ago when we talked, we had just come out of our work from home, 14 months of working from home, and had gone back to the office, and we had just gotten those new MIOSHA emergency rules that you'll recall, getting us back to work and outlining the parameters, the safe parameters under which we were going to go back to work. And it's been an interesting 2 weeks. It seems like we've at light speed gone from walking around in hazmat suits and not going anywhere at all to 135,000 unmasked people at the Indy 500. And I don't know about you, but it's a little weird for me. I mean, I had a meeting today with a client for the first time in person in 14 months. So things are a little weird. And I'm still a little uncomfortable, even though I'm fully vaccinated in a grocery store without a mask on. So I'm still wearing my mask. But we have progressed a long way. We're moving in the right direction, slowly, but we're moving in the right direction. So what are we going to talk about this week? Well, with the kind of paring back of the MIOSHA emergency rules and the euphoria that's kind of surrounding that, and the governor's statement when she announced that hopefully by July 1 we'll be going to no mask rules at all anywhere. In other words, no restrictions, fully open for business. Everybody is thinking about that. They're thinking forward. And I'm going to pull you back a little bit and remind you of one thing. Even if the governor does lift everything come July 1, and even if all the MDHHS rules go away, and even if the MIOSHA emergency rule goes away, even though it's set to not expire till October, but if she lifts that, we still have a rule we have to deal with here in Michigan. And it's not an emergency rule. It's not an MDHHS epidemic order. It is a law. It's Public Act 238 of 2020. And it's called the COVID Employment Rights Act. And don't forget, this is a law. It was passed by the legislature. Remember, when all of this started, the legislature, or some members of the legislature, were angry with the governor. They felt like she had exceeded her authority. They weren't being included in the decision-making process. And as a result of some compromises between the governor and the legislature, we got this bill and two other ones. The two other bills have to do with immunity. But this bill protects employees and employment rights under certain circumstances where they don't come to work because of COVID-related reasons. Now, this is a law. No matter what the governor does on July 1, this doesn't go away. The legislature would have to repeal this, and the governor would have to sign the bill repealing the law. And so, legislature, if you're listening to us, are you going to do that or not? And there's some weird things about this law. The weirdest thing about it is even though it wasn't effective until October 22nd of 2020, it was effective retroactive, according to the act, to March 1 of 2020, which raises all kinds of weird issues that we're not going to get into, that may be constitutional issues that'll be litigated, I'm sure. But it is a bill that protects your employees who don't come to work because of COVID-related reasons. And I want to talk about that just for a minute. So the first thing you need to remember is, except for one exception, the bill says, and this is the meat of it, an employer shall not discharge, discipline, or otherwise retaliate against an employee who does any of the following. Number one is complies with Section 5, including where an employee who displays the principal symptoms of COVID-19 does not report to work and later tests negative for COVID. And we're going to talk about Section 5 in a minute, so I can remind you of the protections this statute gives. The second thing you can't do is fire somebody if they oppose a violation of the act. And the third thing you can't, that's a retaliation provision. And the third thing you can't do is fire somebody if they report health violations related to COVID-19. That's a typical kind of OSHA, you can't fire somebody for reporting safety violations kind of thing. Okay? Now, that exception I talked about, except as provided in subsection 2, is this. Subsection 1 does not apply to an employee described in Section 5 who, after displaying the principal symptoms of COVID, fails to make a reasonable efforts to schedule a COVID-19 test within 3 days after the employer asks them to go. So if you have an employee who calls in sick, says, I've got the symptoms of COVID, hasn't been tested and had a positive test yet, you can ask them to go get a test, and they've got 3 days to make a reasonable effort to get a test. Now, that meant something entirely different when this statute was passed, and tests were harder to get than it does now, where you can get a test almost anywhere. So let's go to Section 5 and the heart of the protections under this act, and they apply in 3 situations. Number 1, an employee who tests positive for COVID. Number 2, an employee who displays the principal symptoms of COVID but who has not yet tested positive. And number 3, an employee who's been in close contact with an individual who's tested positive for COVID-19. All right, we'll start with number 1. An employee who tests positive for COVID-19 must not report to work until they are advised by a healthcare provider or public health official that they've completed their isolation period or all of the following conditions are met. And the current guidance from the CDC is 10 days since symptoms first appeared and 24 hours with no fever without using fever-reducing medication and other symptoms of COVID are improving. Or all of the following conditions are met. If the employee has a fever, 24 hours have passed since the fever's been gone without using fever-reducing medication. The isolation period has passed, so the 10 days has passed, and the employee's principal symptoms of COVID have improved. All right, so that's if somebody who's positive. It's basically what we're talking about here is 10 days in most cases. All right, what about number 2? An employee who displays the principal symptoms of COVID but has not yet tested positive. That employee can't come back to work until one of the following conditions are met. Number 1, they get a negative diagnostic test. So if I've got the symptoms of COVID, I go in and get a negative test, I can come back. Or all of the following have met. Again, the isolation period is passed, the employee's principal symptoms of COVID have improved, and the 24 hours without a fever. So that's if I display the principal symptoms, and I can test out of that, okay? And then the third one is, except as provided in subsection 4, an employee who, in subsection 4 is an exception for healthcare providers and first responders. Except as provided in subsection 4, an employee who has close contact with an individual who tests positive shall not report to work until one of the following conditions is met. The quarantine period has passed since the employee last had close contact with the individual. Remember, the quarantine period varies depending on what county you're in. Some places it's 14 days, most places it's now 10 days. All right. The employee is advised by a healthcare provider or public health official that they have completed their period of quarantine. And those are the 2 situations. Now, again, you can't test out of that. But remember, now under the CDC guidance, if you are fully vaccinated, you don't have to quarantine if you're in close contact with somebody. So why am I telling you this now? This thing's been in place since October. Why am I going over this again? I'll tell you why I'm going over this again. I'm going over this again because the plaintiff's lawyers have finally started to take notice. And when I say the plaintiff's lawyers are starting to take notice of it, there's blood in the water and the sharks are starting to circle. And we're actually getting litigation on this statute in our office right now. We're starting to see the first of these lawsuits start to come in. Again, the sharks are out there clomping. So be really careful of this as you're dealing with your employees. What we don't want to do is give an employee a lawsuit we don't have to give them. Be super careful, and before you terminate somebody, you might want to think about giving us a call if they've been out for a COVID-related reason. So keep that in mind. Thanks, everybody. We'll see you in 2 weeks. Have a good 2 weeks.